Ladies and gentlemen, gentlemen and ladies, sha la 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 la. Ladies and gentlemen, the counting crows are in my background. Anybody ever count crows? Man, that's a difficult job to do, huh? How do you tell a crow from a raven? Not going to have that conversation this time. We're just going to have the counting crows in the background. Ladies and gentlemen, I got a little conversation for you today. We got something to talk about. It's actually very important what we're about to discuss. I hope each one of you have been paying attention to me bringing up the issue of presumption. Now, many of you have let that word go through one ear and out the other because you haven't paid attention, because you don't care. It doesn't affect you. It's not something that you need to be concerned about. And you could never have been more wrong. Everybody wants to know, what are they doing in the courts? How come the courts are doing this? How come the courts are doing that? Why are they allowing this? Why are they allowing... Wait, hold on. Hold on. Stop asking all them questions. We're going to talk about it. Ladies and gentlemen, what we're going to do is we got to go here. Jones and me. Hey, ladies and gentlemen, Mr. Jones and Mrs. Jones coming together. I don't think she's looking at me, smiling in the... When I heard this particular song for the first time, I was in Arizona. I think it was 1996. And I was helping to do drywall stucco. And while helping to do drywall stucco, the individuals that I was with was playing this song. And I listened to it, and I didn't have a copy of it, but every time I would ask them to play this and Hang Around. Round Here, sorry, Hang Around. And this and Round Here, two songs favorite by Counting Crows. I know many of you are going to want to email me, text me to tell me what your favorite songs are. I don't care. I'm not speaking on this. I know many of you think that because I'm speaking the way I'm speaking directly to you. Well, technically I am speaking directly to you, but what I am not looking for is emails that are general, because I don't have time to read them. So if you have something important, a question, well, see, technically questions I don't too much deal with, because they're questions that I've already covered here. Now, if it's something that you believe that I haven't already answered, that I haven't already covered, then yes, by all means, you can ask that question, and I will do the best I can to answer it. However, if I don't respond to your email, please, everybody wants... I'm sorry. Ladies and gentlemen, I want to be a big star. We have different reasons. Believe in me. But I don't believe in anything. Because I want to be someone. Do believe, yeah. Okay, I told you I'm a music connoisseur. You don't just hear me singing along with these songs because I'm pretending to appreciate the songs. These are the songs that I listen to. There are almost 700 songs in that playlist, and I'll be adding more. And yes, the majority of the 700 songs, I would probably say 640. I know. Some of the other songs I've chosen because I like the titles. Do you just choose them because you like the titles? Yes, just like I choose my toenails because I like the way they look. Oh, God. All right, let's get back to the emails, ladies and gentlemen. I cannot respond to every email. You guys, some of you are so limited in your understanding of things. Do not go off of Google telling you how many subscribers and how many viewers and all of that you see on their YouTube. Please don't go by that, because that's misleading. Okay? They purposely are not listing all the people. There are too many of you. God, there are too many of you. I cannot answer every email. Okay, I cannot respond to every email. If you have a situation and your situation requires, I need some help, please, then you're going to have to get a consult. Not because I need your money. I could care less about your money. But that will take time. You need more than one solution. Talk to the people who I've given consults to and ask them, Has he not given me 3 or 4 different solutions? Why? Because you cannot just rely on one thing to get yourself out of a situation. You need as much ammunition as you can possibly get. Do you guys not know about Elijah and him going to that stupid, ignorant king and telling him, hey, the Assyrians, or the land of Syria, you take these arrows. I need you to strike the ground. And Elisha, not Sha, S-H-A, Elisha is blind. He can't even see. And the king takes the arrows and he strikes the ground. 1, 2, 3. And Elisha got upset and yelled at him. He said, I expected you to do far worse than that. You should have struck the ground and pulverized the ground and dug in so deep you should have reached China in its ancient times. But you sat up there and struck it 3 times. That means your victories will only be short, and they will not be decisive, and you will not bring it to its ruin. That's why Syria is still here. Okay, ladies and gentlemen, if you're going to attack something, you might as well go all out. Your attack should not be limited, so you need as much ammunition as possible. That's what the consults do. The consults are not there for us to have a conversation, for us to chit-chat, for us to talk about, shooting the breeze. Okay, I don't have time. By the way, this is Michael, and he's saying, baby, be fun, yeah. Okay, ladies and gentlemen, it's not that a consult is where you're trying to get advice on how to handle something. You have a problem. And especially if it's of a legal nature or a financial nature, then listen to the videos and see if I don't know what I'm talking about, if I can't point you in the right direction. Of course, when we have the consult, I'm going to show you. I'm even going to give you a copy of the conversation. But I'm going to show you where the information is so you can look it up yourself. You'll get a copy of the conversation so that you can pay attention. I want you to pay attention because a lot of people don't pay attention to this, so that you can personally go to each one of the locations and retrace the information. Okay? Now, I was giving 1 hour and a half plus another 30 minutes. I was actually promising everybody a 1-hour consult, but giving them an extra hour. Here's the problem with that. The individuals who I've been giving that extra 30 minutes, in addition to the hour and 30 minutes that they get initially, they haven't been utilizing that extra 30 minutes, and the ones who have been utilizing it haven't been utilizing it within the 7-day period for which we've agreed. That causes a lot of problems because after 7 days, my mind is on so many other different things, and now I gotta regroup to remember what we were talking about. Some of you were supposed to have that 30 minutes. I promised you months ago, and I have never been able to tag team. Get back in touch with me, and we will go ahead and take care of that. Ladies and gentlemen, part of this video is for me to discuss about keeping my word. There's too many of you, so no more promises to you all as individuals. As a group, yes, I don't mind making a promise to a group. But there's too many of you, and I cannot keep my promises to everything. Look at that, Janet and Michael right behind each other in the shuffle mix. That's interesting. I didn't plan that. Okay. Now, Janet is talking about waiting a while. We don't have time to wait a while. You all don't understand what's getting ready to happen, so let me explain it again. Some idiot got on national television and talked that there's going to be a dark winter. He wasn't talking about the 4 seasons. That's a hotel. No. He said it's a hotel! Anyway, he wasn't talking about the seasons for which the earth cycles itself through. He was talking about trouble, problems, difficulties. Go back and just type in, we'll come back to you in a second, Supreme Court. Guys, that case is very important. We will get to it. But let's go ahead and do dark winter. Okay? D A M A M K M W I M N T M E M A M. Dark winter. Let's do. Hey, you know what? I'm interested because he used it in a speech several times. He's an idiot. I don't. Don't choose one over the other because they all idiots. There it is. Dark winter definition. I just want to get the definition. We're gonna get to that Parker case in a minute. Operation Dark Winter. Whoa! What the? What the? Wait, hold on. Operation Dark Winter was the code name for a senior level bioterrorist attack simulation conducted June 22nd to 23rd, 2001. It was, what the, what the, hold on. It was designed to carry out a mock version of a covert and widespread smallpox attack on the U. I wonder, did I know about this? You have my word that I had no idea about no stupid simulation called Dark Winter. I just know when he said those words that, again, like Donald Trump said, national emergency. Those are two very big words, two very important words. Okay? I pay attention to words. The U.S. had a pandemic war game called Dark Winter. Trump ignores its warnings. Dark Winter was an exercise designed to push the system to failure in order to learn about the vulnerabilities. Ladies and gentlemen, this is October 31st. This is from the speech. To get an idea of what a dark winter might mean in the U.S., there is no specific definition here, really, but he said it twice. Joe Biden warns of a dark winter. Now it's here. That's December 16th. My birthday! Anyway, the phrase dark winter, spoken by American politician who foreground the importance of his religious faith. He ain't got no, anyway, has a specific warning to America. Now, I know it's going to say warning to America. This is the Washington Post. Let's see if I'm right. Like I said, I do the anticipation. So let the, if it warning to the American public, okay? Because that's what we're doing. Officially began Monday. Well, certainly. Where's that warning thing at? Has an official blah, blah, blah. I don't see it. Slightly off-brand Biden October. Trump had a monopoly apocalypse and doom, which he inputted Democrats. Whoa, they take sides. Look at that. They talk about Democrats, and they I guess they didn't like Trump because they definitely sat up here and went after him the very beginning of the conversation. So you know that's one-sided. So Washington Post, I was starting to give you guys some credit because I'm thinking that Trump was attacking you, but now I see y'all both attacking each other because y'all got stupidity like that. Hey, we're gonna take this a little bit nice and slow. Warned during the final presidential debate last fall. Now he said it during the debate, but he also said it during a news conference that is now upon us. Winter officially began on Monday. He was not talking about a physical winter. Okay? See, warned, okay, so he didn't say the American public, so I was wrong. But, I mean, he did warn the American public. But, again, as more people travel for the holidays, okay? But that's not what Biden was talking about. Biden was not talking about no seasons, okay? Take a look at when Biden warns of this. He does so again in December. Even though this article is printed in December, Biden warns of a dark winter even after the so-called presidential final debate. Definition of dark winter by Medical Dictionary. Dark winter, also found in Wikipedia, code name for a senior level bioterrorist attack. About the exercise, nobody cares. Dark winter scenario, nobody cares. Dark winter definition, I just put in definition because I just wanted to show you guys that idiot, when he said that, he wasn't just putting words together. He was being specific, not Pacific. The Pacific Ocean is 70 miles to the west of me. Okay? Ladies and gentlemen, down slow. When we're gonna do what? got me saying, my. Pull over. I'm sorry. Give me a second. I have to. My Bluetooth is what I'm playing the music on, and I have it plugged into my external battery pack, and I needed to make sure that it was connected so that it stays charged. Ladies and gentlemen, let me make sure we still recording. Yeah, we still recording. So let's go to the article. As I mentioned earlier, so that you guys will understand, what's about to head our way is not going to be nice. I believe it will be sometime in October, as they like to do their October surprise. Look, today is, I believe it's the 9th. I don't know what the day is, so I can't tell you, but I do believe, no, today's the 10th. I think this is Saturday the 10th. I don't keep up with dates because of my memory issues, so I don't care about dates. Okay, that's why usually if I have an appointment with somebody and they are getting my services, they have to text me the day before. Other than that, I do not keep up with dates. It is just the way life goes for me. Keeping up with dates is too stressful. Worrying about what day it is and trying to remember all the time, I care less. What you saying, Usher? Oh, he's gonna treat her right, he says. Okay, ladies and gentlemen, let's talk about this case right here. Now, when this dark winter comes, it's gonna start. Remember, they're going to start foreclosing on homes. As I told you, ladies and gentlemen, before they foreclose, they do a charge-off. They wait 6 months. That's why they wait 6 months. Do you understand that? Has anybody paid attention to what I just said? They wait 6 months. According to the Internal Revenue Service, they do not have to do a 1099-C. So you don't have to get notice that they charged off your debt. So when you're in foreclosure, go and pull your credit report. Okay? It ain't going to kill you to pull a credit report. So go pull your credit report. If your credit report says charge off on there, know that they have, as a result of that charge off, once they reported it, they have received a credit from the Internal Revenue Service, who represents the federal government. Okay? If they have received credits, remember, tax credits are dollar for dollar. Pay attention. Tax credits are not a percentage, they are dollar for dollar. So that means that they have to offset your balance when they receive credit referencing your account. Pay attention to what I just said, because many of you are not getting it, and I can tell you don't understand what I'm talking about. The moment somebody makes a payment on your car note for you, then the car dealership is supposed to adjust the amount on your balance, the amount that you owe. Well, the bank is not adjusting the amount that you owe. They're not telling you, and they're still kicking you out of the home instead of applying it to your balance and saying, well, look, we just received a lump sum payment of this amount, so now you owe blah, blah, blah. Or now the debt is free and clear, and you don't owe us, mother, okay? That's what the banks are not telling you. That's your fault for not being aware that they are supposed to do that. That's being your fault because you are not documenting your own account. So I'm going to say it again because some of y'all ain't paying attention. Get a copy of your credit report. Okay? Right? If the banks are part of the Federal Reserve by connotation is part of the federal government. Don't worry about it. I know they're a private corporation. However, they're one and the same when it comes to finances as being part of the federal government. So do a FOIA request to them. File a complaint with the FTC. T as in Tom, C as in Charlie, F as in Frank, FTC. File a complaint with them, and then file a complaint with the CFPB, documenting that these received the charge-off. They didn't give me any notice. They're supposed to give me a 1099-C because they reported it to the credit bureaus, which means that they were supposed to notify me. They have violated my rights, and because this charge-off equates to a tax credit, because they have charged it all, means that they've canceled this debt, means that I am liable for the taxes of the amount that has been canceled, and what they have not done is reflected the new balance on my account with them. Wait a minute. They're supposed to reflect the new balance on your account. What you talking about? Excuse me. They just waived part of the fee. They discounted the amount I owed by canceling that amount and agreeing to reduce the debt. Well, if they have agreed to reduce the debt, it's not being reflected on my account. I've asked them for a full, comprehensive verification of account, and they have not provided me validation or verification under the Fair Debt Collections Practices Act and the Fair Credit Reporting Act. They are violating my rights, and I want this taken care of. Ladies and gentlemen, that's all you have to do. You don't need to use me to get that done for you. You don't need to use anybody else to get that done for you. All you need to do is go back and listen to what I just said and do it yourself. Do you guys understand that nobody's trying to siphon money out of your pockets here or at any of the organizations I operate? Honestly, we don't care about your money. That's why we are there to provide the service. Do we care about, no, your monies are only to help us facilitate the services that you are being provided. But we don't care about your monies. Those are yours. Do what you want with your money. However, you're going to have to pay for services for certain aspects of the process. That's just it. We don't have a way around it. So you're just going to have to get it. Get it? Ooh, I got that stuff out of the way because I've been wanting to tell y'all that for a long time. Like I said, there's too many of you. Too many people needing help. And as I've said in the past, in 2012, there was a situation with the Lord Jesus. And as the Lord Jesus, was walking along, and he had this big, huge crowd around him, he like, what you people doing surrounding me? I'm minding my own business. I'm going to the store. Why y'all all around me? Looking up in my mouth like I got something important to say. And while he's telling the people that, this woman walks up to him. I'm just going to fondle your little garment here, okay? You just sit there and talk to them people while I touch you, okay? Well, I'm not going to touch you. I'm just going to touch your little clothes because I see it look kind of nice. Let me touch it. Ooh, look at that. I just touched it just barely, so that shouldn't even bother you. All right, now I'm going to leave now, okay, because I got what I came for. Hey, where you going? Hey, y'all see that? Did y'all see her touch me? I didn't touch you, so yes, you did touch me because I felt power going out from me. Well, sir, you're right. I did touch you. I should have hit you across your head. That way you wouldn't have recognized it was me. Okay? That situation resulted in him saying, I felt power going out of me. As I've said to people, you can zap others of their power by taking their energy. Now, there are certain people out there who believe in the transference of energy. There is some validity to the transference of energy from one person to another. You see it in TV shows where the so-called healers will put their hands over a person and generate their energy towards another person. Again, this is not magic or anything like that. It is actually scientific. And yes, there is a reasoning for that. Remember, we are kinetic creatures. We store energy. You all learned that. Oh, God. Hold on. Because a lot of people, there's a lot of people out there. I didn't mean to do that. Now I really messed up. Yeah, okay. Whew. I thought I got rid of all of them because I wasn't trying to do that. Let's go here to this right here. I don't care about this stuff. We're going to go. Oh, come on. Don't do that. Okay. Did I put him on here? Willie, how you doing? Hey, yo, this is always on my mind. You know, he's been on my mind ever since somebody said that he was, no longer here. And I found out that that was a lie. And I apologize to Willie for actually saying that. So Willie's been here, y'all, and he's been on my mind. Y'all know what I'm saying? Willie Nelson, everybody. All right, ladies and gentlemen, I want you all to pay attention to kinetic. I don't know how to spell kinetic, but Hey, look at that. I spelled it right. Oh, God. Okay. Kinetic energy, ladies and gentlemen. Energy which the body possesses by virtue of being in motion. Now it says the body. I said the body. It says a body. Ladies and gentlemen, watch this. We're going to go back to kinetic energy. I didn't ask for potential. Okay. I know human means monster under some 18th century piece of... Okay. I know human means monster under some 18th century piece of... Okay, but I don't care. I'm using it for just this definition. Kinetic energy is built up in an object by motion and can be defined as energy that is needed to either slow it down or speed it up. Kinetic energy is also generated by the human body when it's in motion. Ladies and gentlemen, kinetic energy is not just generated by the human body when it's in physical motion moving forward or backwards, but as your circulatory system is moving, your body is producing energy. You are a creature of energy. You may not have realized that. So, again, when he said, I perceived energy going out of me, again, we have the ability of transferring energy from one party to another. There you go. So there is no issue. There are people who are studying this, and there are some people who've made a religion out of it. Then you have your faith healers, okay, who really take it to another level that he didn't authorize. You heard me. He did not authorize that. Go back and look. What I'm mentioning is that, ladies and gentlemen, many of you have had the comment and conversation with me that after talking to me, you feel mentally tired, you feel exhausted, you feel mentally drained. Ladies and gentlemen, you have no idea how mentally drained I feel at the end of each day. From having all the conversations, from doing all of the thinking. That's why I am exhausted every day, not to mention the kidney, quote-unquote, damage that I have. Your kidneys is what stores most of the energy in your body. That's where your energy comes from. So if you're feeling lethargic and lackadaisical and lazy, I said feeling lazy, not that you are lazy. Some of you are very lazy. Some of you are lazy by nature. And anyway, ladies and gentlemen, go and have a kidney test done. Just have the doctors check your CK and CP as in Paul, C as in Charlie, K as in Kevin, and C as in Charlie, P as in Paul, K as in Kevin levels. CK and CPK levels. Have them check that. It wasn't until they checked my CPK and CK levels that we were able to determine there was a problem. Guess what? The doctors, when I went through the operation, they knew this. This is the blood test they could have ran that would have prevented me from dying on an operating table for 18 minutes. It's a simple test. Just siphoning blood out of your arm, running the test, takes less than a day, and you get the results. That may not be the only issue for your tiredness, your fatigue, but have them check your CPK levels in your kidney. That will show you the level of energy you have. That will show you if there's a problem. And then they can go ahead and prescribe. See, in my case, there is no cure. I don't give up what you say. Sorry, because there are some people in the audience who are sitting up there talking about, yes, there is! If there was a cure for muscular dystrophy, ladies and gentlemen, people would be getting up out of them wheelchairs. Okay, they literally would be getting up out of them wheelchairs. Just that simple. But I don't see it. I've not seen one single person cured of muscular dystrophy in my entire life or before that. Jerry Lewis ain't seen one single person cured of muscular dystrophy. And he ran the muscular dystrophy telethon for the Muscular Dystrophy Association. The Muscular Dystrophy Association is a joke. Let me let you guys know that. They take in all of that money and they are a joke. They're not trying to help nobody. They're just trying to keep the status quo, keep the money coming in. They're not trying to help the people who are on muscular dystrophy, nor are the scientists who are creating this medication. The medication has so many side effects, it's pathetic. That's why you see they've made no advancements with muscular dystrophy. Don't believe me? Just go and do your research and see that there are no advancements. As a matter of fact, they're adding more and more symptoms to the likelihood of muscular dystrophy now than ever before. But they're not coming anywhere near close to any form of a cure. Like I said, that's the truth. Okay, let's go back. Who we playing now? It's Gladys Knight. This is a new song. She says, I hope you can dance. Okay, I hope you can dance, Gladys. Yeah, that's an old picture of you, Gladys. I know. That's my girl Gladys, y'all. Now, she gonna be in a... It almost sounds like the beat, Look Into Your Heart. You know. I mean, Listen to Your Heart, sorry. See, I do catch myself when I make a misspoken statement. Look, hey, Richard, McKinley, Wilson, Jr., Bay. This was actually pretty nice what you did. Ladies and gentlemen, would you guys like to know what Richard, McKinley, Jr., Wilson Bay did? Yes, he's a Bay. Mr. Wilson is a Bay. B-E-Y. Why is he sitting on that thing? Tell him to get off of that thing and get on and go on with his life. Tell him ain't no need to be sitting on no bays on nobody's dock. Oh, God. Anyway, ladies and gentlemen, Mr. Bay did something that many people have been thinking about doing, but had not known what to do. Mr. Bay was not no little lethargical individual. This was filed in the Supreme Court of the United States, December 4th, 2018. This was a petition for a writ of certiorari. It came from the Office of Tax and Revenue, the Office of the Commissioner of the Revenue and Tax, Stanford County. Stafford, man, I knew Stafford, that mother... Okay, ladies and gentlemen, petition a writ of certiorari. See, I told you it was a Bay. And he came in pro se, no attorney. He did a writ of certiorari. Let me tell you something. Y'all just don't understand. Let me tell y'all what Mr. Bay did, okay? And he's in Providence of Virginia. You notice how he did his address? Okay, let's see if the Supreme Court recognized Mr. Bay's position. Now, I need to show y'all something so that y'all understand. This is in the Supreme Court of the United States. This is not in the United States Supreme Court. This is in SCOTUS. S-C-O-T-U-S. This is in SCOTUS. The proper jurisdiction. I told all of you, go to the Supreme Court. Send them a cover letter. Let them know that you are trying to petition the original jurisdiction under the United States Constitution, under its common law provisions, under the Bill of Rights. You have a complaint. You have a redress petition that needs to be heard by an impartial body that is governed under common law as evidenced by the Bill of Rights of the Constitution. And according to the United States Constitution, this is the body vested with the judicial power, and you need them to assign this to a court under that judicial power which has been assigned to it by the people. That you need to know what the process is for doing such a thing. If they could please provide you that process, and please do not provide me a statutory remedy. I want a constitutional remedy, as statutes are only prima facie evidence of law. Now, there's a reason why you had me say that whole statement, because we got to talk. Because that's what this is going to be long, so get some popcorn. Hey, Mama, you were right. You're bringing the popcorn in here. He say this is going to be a different conversation, and it's going to be some important information. So you bring that popcorn on in here, Grandma. Okay, all right. I'll see you in a minute. I'm going to finish listening to him. All right, you can go on in. I'm ready. Well, thank you. I appreciate you giving me permission. Don't finish mention it, no problem. Now go on now, you're getting on my nerves. Now go on. Okay, ladies and gentlemen, let me tell you what Mr. Bay did so that you guys will understand. And no, I haven't looked at the whole case. Here's the reason. Because I just got this morning. You know, as some artists would say, I just made the mother up last night. Well, I didn't make this up last night. I just found this morning. Okay? Questions presented. See, he asked questions. In this case, the petitioner officially proclaimed his true nationality by repatriating back to his newly reestablished nation state. Mr. Wilson Jr. Bay! You go, boy! You go, boy! Okay, sorry. Hold on. Provisions of the state charter and the constitution of the petitioner's nation, state government precludes the Commonwealth / State of Virginia and Stafford County entity from subjecting the petitioner and his property to its taxation statutes and ordinances. Now, ladies and gentlemen, I don't know what the Supreme Court decided in this case because I haven't read it. We ain't going to read the whole case. Y'all going to go read it. Okay. Due to the preclusions, the petitioner petitioned. Hey, this Rick James? Hey, y'all, he busting out. Okay. The petitioner petitioned to have his property excluded from the tax rolls of Stafford County entity. The lower court asserted that it lacked jurisdiction to recognize the authority of the nation state. The question presented focused on whether or not the courts of the Commonwealth of Virginia have the jurisdiction to recognize the authority of the petitioner's nation state and whether the courts shall so that the petitioner may enjoy the legal protections recognized and provided under his nation-state constitution that precludes the taxation of his property by the Stafford County entity. Now, do you guys see the question? Now, look at what the Supreme Court says here. The questions presented are, do the courts of the Commonwealth of Virginia have jurisdiction to recognize the authority of the petitioner's reestablished nation-state? Do the courts of Virginia have an obligation to recognize the rights of the petitioner that are recognized under the provisions of the Charter, Constitution, and laws of the petitioner's nation-state government that stem from the recognized rights under the provisions of the Constitution, laws, and ratified treaties of the United States? You see, he went under the Constitution, treaties, and laws of the United States to form his nation state. I know some of you are going to get this ideas, but you saw his email address. It's associated with his filing. Why don't you write him? Now, I'm not advocating for Mr. Wilson. I don't know Mr. Wilson. He ain't my buddy, my partner, my friend. I just have respect for the man for what he did. Okay? Was he successful? I don't know. Did he bring a conclusive argument before the Supreme Court? Please understand, I'm getting ready to do something similar regarding arbitration. I just want all of you to know. When I told you, if you got to file a lawsuit, why don't you do a notice of removal to constitutional jurisdiction, to a constitutional court, and why don't you send it to the Supreme Court for assignment? You have the right to do a notice of removal. Okay, now the statute says notice of removal to federal court, but you have a right to do a notice of removal to constitutional jurisdiction. And that's what I would be trying, ladies and gentlemen. I can't tell you how to do that, but that's what I'd be trying. Okay, hey, busting out, y'all. La 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 la. Rick James. I'm rich. I'm sorry. Anyway, parties to the proceeding. The parties to the proceeding below are, and it lists all of these. You got Richard McKinley Wilson Jr. Bay. You notice how I used the colon? Pay attention. Also known as blah blah Jr. And now see, I don't know if he put also known as or did the court put also known as, because they like to do that. And the respondent, Office of the Commissioner of Stafford County, and the Commissioners of the Revenue. There are no non-governmental corporate parties requiring a disclosure statement under the Supreme Court 29-6 rule. Well, guess what? I believe that the Supreme Court right there, when the clerk of the court documents that, or the court documents that they're going to consider this as statutory. I know that there has to be a reason for them using their statutorial rules. Okay, let's go. Questions presented, parties to the proceedings, table of authorities. Whoa, they got authorities. Petition for writ of certiorari, opinions below, jurisdiction, constitutional, statutory, treaty provisions involved. You see? Statutory and treaty provisions. So they did statutory. So, just like I figured, reasons for granting, they granted his petition, y'all! They granted his petition. The court's review is warranted to ensure the petitioner's recognized rights under the 9th and 13th Amendment. They said 14th Amendment. The petitioner didn't come there under the 14th Amendment. I hope he documented that he's not there under the 14th Amendment. And under the ICCPR are not unlawfully stripped. Okay, Supreme Court just said that this individual who just formed his own nation is now under the 14th Amendment, which is impossible because you don't have any rights under the 14th Amendment. You have privileges and immunities. I mean, benefits, privileges and benefits and immunities. But you don't have any rights under the 14th Amendment. Go back and look at the 14th Amendment. You don't have any rights under the 14th Amendment. Benefits, privileges, immunities is all you have under the 14th Amendment. Now you have secured rights under the first 10 amendments, the Bill of Rights. That's why it's called the Bill of Rights. The 14th Amendment, the 11th Amendment, the 12th Amendment, the 13th Amendment, the 15th Amendment, none of those are rights. The Bill of Rights are your rights. Anything outside the Bill of Rights are not rights. That's why it's called the Bill of Rights. They didn't call it the Jim of Rights, the Jane of Rights, the William of Rights. Well, they did call it the William of Rights. No, they said Bill. William and Bill are the same person. Go and ask Barnacle. Okay. The court should resolve the matter of the courts of Virginia with respects to the lack of jurisdiction to recognize the authority of the petitioner's nation-state government. See, they should resolve the matter because he created his own nation-state within a state. That happens all the time. Every city government does that. Okay, 2 reasons I cried. That's genuine in my background, y'all. This case outlines the questions presented. Then they got their conclusions. That's 23 pages. We ain't going to read 23 pages. Appendix A, order in the Supreme Court of Virginia, and then order in the Circuit Court of County of Stafford, and, he did Rooker-Feldman. What the, ladies and gentlemen, no, let me explain because some of y'all might not be understanding. Okay, what happened is he started in the lower court. Okay, and he even, look at that, House of Representative excerpts and everything, but when he started in the lower court, he got an order from the lower court, then he went to the appeals court for the lower court, then he went to the Supreme Court of the state. Once you go to the Supreme Court of the state, on constitutional issues, you don't have to go to the federal district court. You go straight to the Supreme Court of the United States on writ of certiorari. It's called Rooker-Feldman principle. Rooker-Feldman rule. Rooker, R-O-O-K-E-R, Feldman, F-E-L-D-M-E-N. Okay? Rooker-Feldman. All you got to do is do your research. Rooker-Feldman, that's what you do. That's what he did. Now, let me do this for you. Because there are a lot of people out there who are claiming I don't know anything about the law. Which is, it's offensive. Because that means that they're experts when we're all required to know the law. I know that there are supposedly 9 principles of statutory interpretation. Supposedly. But they keep adding. Okay? That's why I say supposedly. I know, as you're going to learn later, that the U.S. Code is not law. We're going to talk about that in a minute, okay? So let's see what we can do about this stuff. Let's read the case. Now, I'm going to have to pause y'all for just a second. Y'all, would you please excuse me for just one moment? Genuine says there's 2 reasons he cried. And I can't tell you how many reasons I cried because it's more than 2. Okay, ladies and gentlemen, before we go on, I need to explain something. Got a question. I went to Home Depot, and I asked the young lady, the greeter, I said, excuse me, are you all mask on or mask off? She said, what'd you say? Huh? What'd you say? I said, excuse me, are you a mask on or a mask off facility? Oh, well, I wear my mask all the time, but if you want to, that's up to you guys. Well, thank you. She says, yeah, I wear mine all the time, and ever since I've been wearing my mask, I ain't caught no cold, I ain't had the flu or nothing. And we had a little short conversation based on that comment right there, and I told her I've had the COVID twice. Oh, I'm so sorry to hear that. Woman, thank you for your condolences. Now get out of my face so I can go do my shopping. Oh, I got a question. Yeah. Have you noticed that there's been nobody talking about they caught the flu or had the flu or anything, or you don't see nobody sick with the flu since we started this whole mask thing? I said, wait a minute, hold on. Look here, wench. You might have something there. What you call me a wench for, mother? Do you know that this is a right to carry state? So what you say? I'm sorry, ma'am. I didn't mean no offense by that. It's like it was Texas or something, wenches and all that stuff. Well, it's an ancient language thing in English. It's one of the original. So I didn't mean no harm behind it. Oh, you all right now? Let me put this back here and conceal it because I don't want the next person to think that they can just get away with something like that just because. Okay, she wore a raspberry beret when I was talking to her. And she was working part-time. And her boss name was Mr. McGee. Okay? Didn't like my kind is what they told me. Okay, ladies and gentlemen, I'm just bringing it up because I want to ask you, because she was astute. She noticed that nobody around her seemed to have complained about catching the flu. I happened to catch the flu at least twice, 3 times, 4 times, 1 year, 3 times in a row. Right after I got rid of it, a couple of days later I caught it again. Well, you could have already, no, I guarantee you that I knew I caught it again each time because you can feel the flu. The flu is like some, oh man, what's that? Man, you know what that feel like? That feels like the flu. Oh, God, I got the flu again. Okay, that's how that was. So I know for a fact that it was 3 times. 3 times in a short period of time. In a 6-week period, the flu 3 times. The way I get rid of the flu is through vitamin C. So I have a cabinet stocked full of vitamin C. I have another cabinet with vitamin C. Vitamin C is my best friend. Me and vitamin C, we go hand in hand. Hey, vitamin, let go of my hand while I'm talking. See, I told you he's right there next to me. Vitamin C, don't leave me. Okay? And we ain't got that little jug with the juice in it walking around with a big, huge smile on his face talking about Kool-Aid. That ain't the vitamin C I be talking about. That ain't the vitamin C. I be like Mr. Trump shooting that stuff right up into my veins. No, I'm joking about that. I forgot what he was shooting into his veins. But apparently it had an effect on his mental capacity. Okay, ladies and gentlemen, as I stated, I would normally catch the flu quite often during the winter season. Very seldom do I get it during the summer, but I've had the flu during the summer at least once or twice in my lifetime. However, very susceptible to the flu, and so I stay away from people. As I mentioned to all of you, because I knew there was a pandemic coming, and I say coming, not already here. That junk was not the pandemic that I knew and saw. What you saw in India was like a precursor to what I saw. Okay? Where the people were in despair, where they didn't know what was going on, where they didn't know who was going to die next. That's what I saw. And I saw it on a wider scale. So let me explain it to you so that you guys will understand. That's what's coming. And if I'm wrong, hey, all the better for everybody else. I'm hoping that I'm wrong. Okay, but I can't be wrong because the scriptures make this promise. Those of you who know anything about scripture, I want y'all to do me a favor. I want y'all to burn some rubber. Y'all know about this song right here. But the down. That's right. We gonna burn some rubber today, y'all. The Gap Band. Okay, ladies and gentlemen, for those of you who really need to have a better understanding of what's going on, there is a scripture in the Bible that talks about a great tribulation, which has not occurred since the world's beginning until now, no, nor will occur again. Will never happen again. Ladies and gentlemen, it says that if it were not for the sake of a certain group, no flesh would be saved. There are 8 billion. There's 7 billion, 6 no, 8 billion people on the planet. How do you know there are 8 billion and not 7 billion, 600? Because they are estimating, and they're not rounding up. They're estimating, and because it's on a global scale, we can't have more people because that means that they would have to allocate more money. They're estimating downward, not estimating up, because if you have more people, that means you have to do more for the people. They're part of the UN. Plus, there are a lot of nations and a lot of places where they have no articulation as to how many people are in those areas. So, again, it's all estimates. All right. Well, anyway, since it says, if not for the sake of this group, no flesh would be saved, pay attention. In order for it to get to that point to where people are going to think that nobody's going to survive, that it's the end of the world, Ma! Oh, top of the world? No. He says end of the world. Oh, no, he says top of the world? Tupac? Yeah, Tupac said, oh, yeah, he did say it's top of the world, Ma. Okay, yeah, so that's how I remember that movie. It's Tupac, because Tupac said top of the world. So, there we go. Ladies and gentlemen, in order for it to get to the point to where no flesh would be saved, that means billions of people would have to lose their life. That's what I saw. Not making it up. Didn't even understand that aspect of things prior to understanding the understanding. So, all I can tell you is it's coming. They promise us a dark winter. So before that dark winter comes, start taking care of your finances, start taking care of your business, because guess what? You know what happened after the Great Depression? You know what happened after the Great Depression. All the people who weren't prepared financially, who did not protect their interests, you saw what happened to them, right? They lost everything. They lost their land. So, again, stop letting the banks take your land from you after they do a charge-off. That's illegal. I've been really yelling this out to people since 2012. I've already given you the argument. They receive a credit. I've already shown you the court cases where the courts have said that they receive a benefit, that they now want you to prove that the banks have benefited. Then let me have discovery. See, in the case against PennyMac, we're trying to prove this exact same thing. Guess what the courts won't do? They won't issue an order mandating a response to our subpoenas. Not a single subpoena has been responded to, because why? They know that the court is never going to permit it. That's why I tell you, anytime somebody sues you, you always countersue. And yes, we'll be going straight to the Supreme Court with this PennyMac case. I don't care. They want to play with me. I want to play with them. Because I ain't got time for people. They attacked me and my company. And if they keep playing with me, I am going to go on the attack. I am going to get their attention through their own system, through their own court system, through their own paperwork. I am going to... Anyway, sorry. That'll be me letting them know what my strategy is, and I ain't going to let them know what my strategy is, because they ain't got no business knowing my strategy. Wait. Exhibit N explains the situation, which demonstrates how, if the court were not to review the case and to make determinations, would facilitate in stripping USAR of its rights. United States, I don't know what AR stands for. I believe that might be the, that can't be United States Air Reserve. I doubt that. As a governmental corporation from engaging in commerce. Whoa! From engaging in commerce, so I believe he may have brought up the engaging in commerce issue and how they are not government. The government does not have the right to engage in commerce. They don't have that equal protection of rights. The rule is anytime government engages in commerce, they abandon their sovereign capacity, so they don't have equal protection of right. Okay. The ICCPR General Comment Number Human Rights Committee, 8th session, March 2004, their 2187th meeting relating to the nature of general legal obligations imposed on state parties to the covenant. So, look, ladies and gentlemen, I really do believe that this gentleman has stepped onto something, and I believe that he knew, and I wish he had gone in as a class. Okay, let's go. This one is, he loves me. Somehow he loves me. This is Gladys Knight, and this is Just for You soundtrack. Now, see, I myself would not have used the articles. And see, he used the 13th Amendment, the 14th Amendment. Well, the court is using the 13th and 14th Amendment. You see, they're using the 13th Amendment, which should not be used by any of you because it's not a right. It's not a constitutional right. 13th Amendment is a privilege. The privilege against involuntary servitude, it's not a right anymore. They made it into an amendment to their statutory provisions of the Constitution. Okay, go ahead and look at the articles, ladies and gentlemen. The people didn't sign the articles. People signed the amendments. The first 10, the Bill of Rights. That's what was put into the record. What is it that? I don't give about any of that other stuff. Okay? U.S. ratified treaties. International Covenant on Civil and Political Rights. International Covenant on International and Political Rights. Ladies and gentlemen, how come we didn't hear about this case? Because there are some decisions made in this case that benefits all of you. And this much I do know. Convention on Rights and Duties of States. This young man was no joke. But I don't like the fact that they brought in statutes, especially 42 U.S.C. You cannot mix statute with constitutional rights. And when I say constitutional rights, pay attention. Constitutionally secured rights is the correct phrase, because the Constitution secured your rights, and I've known this for years. That's why you keep hearing me correct myself and speak about secured rights. Okay, the Constitution did not grant a single person a right. It never did. That's why it doesn't apply to citizens, because it's common law. Common law applies to everyone, citizen or not, even applies to children. Common law does not, well, technically it does apply to businesses because businesses have the right to exist. Corporations, everything is a corporation. Anytime you bring two or more people together, that's a corporation. Two people incorporated. Whether it's a conversation or an agreement, it's a corporation. So, yes, they have the right to exist. Okay, and then they brought up the common, the Commonwealth codes. Citizenship of the United States, expatriation and protections abroad, House of Representatives document number. So he expatriated himself. General comments, Human Rights Committee, and United States report on ratification of International Covenant Civil and Political Rights, United States Senate. Okay, come on now. Petition for writ of certiorari. Petitioner Richard McKinley Wilson Jr. Bay, called anyway, by the respondent respectfully petitioned the court for writ of certiorari to review the judgment of the Supreme Court of Virginia and the Circuit Court. Okay. Oh, hold on. You see, I said the respondents call him without the bay. Says that he petitions the court for writ of certiorari. The opinion below. The order of the Supreme Court of Virginia is reprinted at Petition Writ of Certiorari Appendix A 1 and 2. The order of the Circuit Court of Stafford motion to reconsider is reprinted in 3 and 4. The order of the opinion of the Circuit Court of Stafford is reprinted. Jurisdiction. The petitioner seeks review of the decision of the Supreme Court of Virginia. The judgment of the Supreme Court of Virginia is entered September 18, 2018. The court has jurisdiction over this timely filed petition pursuant to 28 U.S.C. U.S. Code. Ladies and gentlemen, I promise you, long video, but you're going to learn about the U.S. Code. Okay? The U.S. Code should never be used. We've been using the U.S. Code. Stop using the U.S. Code. We're going to talk about that in a minute. Constitutional, statutory, and treaty provisions involved. The impairment of obligation of contracts clause of Article 1, Section 2, and this is how all of you win. Pay attention. All of you win your arbitration appeals. The impairment of obligation of the contract clause, Article 1, Section 10 of the United States Constitution provides that no state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisals, coin money, emit bills of credit, make anything but gold and silver coin a legal tender in payment of debts. Ladies and gentlemen, as a matter of fact, I'd be using this. Pay attention. I would be using this in my appeals. Why? Because it says no state shall make anything but gold. Pay attention. No state, not the government, no state shall make anything but gold and silver coin a tender in the payment of debts. Pay attention. So how are you required to pay a debt? If you go to court on a foreclosure, then you need to show me where I'm going to get gold and silver, since the government seized all quantities of gold and silver in an amount for which I can pay this debt. And according to the law, the Constitution, not your state little stupid statutes, the Constitution, you cannot require anything but gold and silver. And now that since you've taken gold and silver out of the economy since 1933, what you have done is you prevented me from paying my debt, which means you created an impossibility. You can't foreclose on me because you are the problem. That's what I'd be saying. Just want to make sure. Okay. And we don't want to talk about or make any law impairing the obligation of contract. Now, ladies and gentlemen, when the courts block your contract because they just say words, they don't provide any proof, they use case law to respond to your contract, then they're impairing the obligation of your contract. When they're denying an arbitrator an arbitration award based upon whatever, not listening to anything, not giving any evidence, just making statements, they're impairing the obligation of contract. Supreme Court understands this, and if you bring the question the correct way, they have no other choice but to rule the correct way. That's why we have almost 12 appeals in the appeals court right now that are at a standstill, not moving forward, not moving backwards. Okay? All right. The full faith and credit shall be given each state in the public acts, records, and judicial proceedings of every state, and the Congress made by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Ladies and gentlemen, it's called the full faith and credit clause. Now, it's just not the records, because this stuff was added later. It was amended later. But the full faith and credit clause basically says, pay attention, the states receive full faith and credit. The states receive their full faith and credit from the people. The Constitution and the laws of the United States, which shall be made in pursuance thereof. Constitution, remember, the laws can only be made in pursuance to the Constitution. The First Amendment says Congress shall not make any law abridging your rights. Congress shall not make any law abridging your rights. So when Congress made laws abridging your rights, they violated this clause. Just that simple. There is no ifs, no ands, no maybes, no waybies, no nothing. They violated your rights. Okay. The enumeration of rights clause, Ninth Amendment. Enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Like I told you, the first 10 amendments do not talk about anything about privileges, okay? Does not talk about anything about benefits. They talk about rights. That's why it's called the Bill of Rights. Second, first 10 amendments doesn't say anything about no citizen. It says the people. Who are the people? They're the people of the respective states collectively. That's who the people are. Why? Because the people make up the state. And the states make up the United States. So the people wasn't this special class of people whom nobody knew who they were. No, the people were the people of each respective state. That's why you come in as a state citizen, under your state's rights as a state citizen. You skip all of that 14th Amendment citizen because that's a United States citizen. There's no such thing as a United States citizen. That was an invention. Each of the people of the United States are citizens of their respective states. So just like I am a citizen of the state of California, the United States of America. Do you follow me? Involuntary servitude clause. See, it's a clause. It's not a right. Neither slavery nor involuntary servitude, except for punishment of a crime, whereof a person shall have been duly convicted. See, duly convicted. How are they convicted? What's the duly part? Oh, that's on the back of a truck, and some of these trucks, they can pull up to 8,000 pounds, and someone can pull 30,000. Oh, not that type of dually? Oh, okay, I'm sorry. I'm going to shut up now. Okay. See, all persons born, what about an unborn person? One who repatriates themselves is unborn. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Well, I was not born in the United States. I was born in the state of California. Go ahead. Check my birth record. I was born in the state of California. I'm not a United States citizen because United States citizens are those who were born in the United States. Sorry. You can't even show me where the United States is. Go ahead. Show me where the United States is. Now, don't look at no map and don't look at no TV screen. Show me where the United States is. Anybody? Can anybody point out where the United States is? Then that's it. Because there's no such thing as the United States being a geographical location. No. The state of California is a geographical location. State of Arizona is a geographical location. Those geographical locations, when you combine, make up a united confederacy of states. That's why it was called the Confederacy. Well, there was no United States. You have to combine all of the states. Okay? Which means you have to combine all of the people of those states. Now we're going to do statement of case. The petitioner, pay attention, is an Aboriginal and indigenous Moorish American national born May 20th, 1964. Hey, he's a couple of years older than me. In the United States of America, for the purpose of gaining his loss of nationality, the petitioner repatriated back to his reestablished nation state, the United States of the American Republic, USAR. Okay, that's what USAR stands for. The United States of America Republic. And guess what? They actually spoke about that earlier in talking about the rights retained by the United States of America Republic by taking an oath of allegiance. Now, I will never take an oath of allegiance to any country, any state other than my God and his kingdom. It's just that simple. Due to the petitioner's acquiring his new nationality, political status, legal relationship, and attachment to the United States of America Republic, he submitted, pay attention, submitted to what? An informal hearing to the respondents for the purpose of removing his property from the Stafford County entity tax rolls for the purpose of taxation due to the petitioners now being domiciled and residing within the province of Virginia under the ownership and jurisdiction of the United States of America Republic. The respondents denied the removal of the property from the tax roll. The basis given for the denial was due to the English tradition to subject property to taxation. Well, what about the fact that private, personal property under Article 9, Section 102 and 109 for household goods, consumer goods is exempt from such taxation? Sorry. Well, I thought you said don't use statutes. Well, basically, the right to property. See, if it's a right, you cannot be taxed on a right. Nobody can convert a right to a privilege. So they make it a privilege to own property. Cannot be a privilege. It has to be a right. That's how you handle that. Okay? Number 3, that the authority to tax property is derived from Article 10 of the Constitution of Virginia, 58.1, subsection. The Code of Virginia and Virginia laws in accordance with the Constitution of the United States of America. Seeking the administration of justice, the fair and just and impartial upholding of constitutional rights according to the rule of law, the petitioner petitioned the Circuit Court of Stafford to resolve the matter by upholding these recognized fundamental human, civil, and political rights and freedoms which are expressed within certain provisions under the United States Constitution, international covenants, and declarations ratified by the United States under the Constitution and laws of the petitioner's nation-state government, which precludes the Stafford County entity from subjecting the petitioner his property to its taxation ordinances, which exclude the property from the Stafford County entity tax rolls. Being opposed to the petitioner, respondents submitted a demurrer, seeking to have the petition dismissed to avoid having to prove at trial jurisdiction and the authority of the Stafford County entity to tax the petitioner's property, and to avoid disclosing certain facts within the court. Now pay attention. Let me let you guys see this again, because this is how I pay attention. The petitioner, it says the Stafford County government entity filed a petition to demur, seeking to have the petition dismissed to avoid, they wanted to dismiss to do what? To avoid, they wanted to dismiss the petition to do what? To avoid having to prove the jurisdiction and authority of the Stafford County entity to tax the petitioner's property, to avoid disclosing certain facts within the court. And then they show exactly the motion where they actually said that stupid thing. At the hearing on the demurrer, the respondents neither rebutted nor refuted the certified evidence presented by the petitioner, which evidence proved, facts and conclusion of law, ladies and gentlemen, that the petitioner had in fact repatriated. Whoa, wait a minute. The Supreme Court has said what this gentleman did was official. He repatriated himself. Pay attention. And the United States of America Republic Charter is in fact official. Lord have mercy. And that the certificate of authority is in fact official. And the Providence of Virginia jurisdiction does in fact exists, and the respondent was subject to the provisions of the Constitution, laws, and ratified treaties of the United States. On February 21st, 2018, during an argument on the demurrer, the petitioner on 2 occasions communicated to the court that if it were not to recognize the United States of America Republic as a state, it would be subjecting the petitioner and the United States of America Republic state to servitude under the Commonwealth's political body, referring to the 13th Amendment of the United States Constitution and Article 8 of the International Convention of Civil and Political Rights, ICCPR. The circuit court sustained the demurrer and dismissed the case with prejudice by final order based upon the grounds that the circuit court, then how can you dismiss it? Pay attention. How can you dismiss it with prejudice if you say you don't have jurisdiction? It says does not have jurisdiction and could not recognize the authority of the petitioner's nation state. The circuit court also communicated that it is mandated only to the provisions of the Constitution and the statute of the Commonwealth of Virginia and Stafford County that were present in support of the petitioner or the respondent's petition. Ladies and gentlemen, let me do you guys a favor. The circuit court said all of this about this young man. This young man did not take what they said as law because it was just some idiots making a comment. So what did he do? He appealed it to the Supreme Court. The Supreme Court of the United States is pointing out exactly what happened, what took place. They're not, they do it from time to time, but they're not doing it here. They're not telling you, supposing he said this, supposing he said that. They said his repatriation was correct. His document constituted evidence. Pull the case from Pacer. Anybody wants to pull the case from Pacer and send it to me, I'd appreciate it. We have a Pacer account, and I'm probably going to send my people on this case because I'm interested in Mr. Wilson Jr., Bay, and what he did, because this young man did what he did, knew what he was doing, and I give him credit. And I don't think that he's like the other Bays in the past who go into court arguing and all of that, yelling and screaming, because that's not how you do things. Ladies and gentlemen, he knew the court was going to do what it did. He didn't argue with them. He followed the process. He went all the way up the ladder. He did the Rooker-Feldman. I don't know if he knew he was doing Rooker-Feldman, but of course he did because he went straight to the Supreme Court. So he Rooker-Feldman those mother... Okay. On February 28, 2018, the petitioner, they keep saying submitted. Okay, that means you're submitting to the jurisdiction. I'm not. I don't submit nothing, mother. Okay, submitted a motion to reconsider, which objected to the February 21st, 2018 order. The motion expressed how the court failed to require the respondents to submit evidence to prove the petitioner's political status, nationality was false, untrue, or invalid. The motion expressed that by the court's failing to recognize the authority of the petitioner's nation state and of the rights secured by the petitioner to the petitioner, see, secured rights, secured to the petitioner under the Constitution and laws of his nation state, also violates the petitioner's secured rights under the United States Constitution and laws. It further expressed how the Constitution, how, by the court ignoring the petitioner's nationality, caused the court to subject the petitioner and his nation state to servitude under the Commonwealth of Virginia. On March 9th, and ladies and gentlemen, that's what you all do on your appeals. By the court failing to recognize your right to arbitrate, your right to enter into contract, they're subjecting you to servitude. By the court failing to prove jurisdiction, it's subjecting you to servitude, violation of your right to freedom, liberty. See, that's why you don't need a servitude clause, because, pay attention, the right to liberty is a right. The Constitution didn't give it to you. You have that right automatically. All right. The petitioner then filed a petition for appeal to the Supreme Court of Virginia. In the petitioner's argument, he expressed, and the circuit court is the quote-unquote technically the first level, and then you have the appellate level. In California and other states, we have a 3-level court system. You have the Superior Court, Appellate Court, and other states call their Superior Courts district courts or circuit district courts and things like that. But you have the City Court, the County Court, the Appeals Court, Supreme Court. That's usually the way it is in most states. They call the City Court Justice of the Peace Court or Metropolitan Courts and stuff like that. So that's just letting you guys know that how it is normally. Okay, sorry, I'm rearranging some things in the background because we got a breeze coming in. And I need this breeze because this is one of the hottest days. It's 97 degrees. Sorry, apologize. The petitioner filed a petition for appeal in the Supreme Court of Virginia, and the petitioner's argument was he expressed that based upon the Constitution, laws, and ratified treaties of the United States, that the circuit court does not have the power and grant to jurisdiction to recognize the authority of the, does have the power and jurisdiction to recognize the authority of the petitioner's nation state for the purpose of securing certain rights invoked by the petitioner and for the purpose of fulfilling certain international obligations under the CCRP. On August 30th, 2018, the petitioner was permitted. See, permitted. Pay attention to the words they use. Somebody gave him permission to argue the reason why the Supreme Court of Virginia should take up the case. The petitioner expressed that the obligations that the United States and the Commonwealth and the state of Virginia have under the CCRP, or CCPR, sorry, I don't know why I want to say RP, CCPR, expressed that ratification of the CCPR and the obligations and duties that come with its ratification grants at the very least the jurisdiction to said courts to recognize the authority of the USAR so that the court may ensure that the Commonwealth and state of Virginia fulfills its obligation and duty under the CCPR, and express that the right to self-determination is recognized by the CCPR, and the authority of the United States of America Republic represents the delegated powers of the Moorish American nationals, of which power in part represents the fundamental rights of each individual national citizen of the United States of America Republic, as well as their collective rights to self-determination. The petitioner also expressed that if the circuit court could not truly have jurisdiction, then the Supreme Court of Virginia does not truly have jurisdiction. The Supreme Court of Virginia does pursuant to Article 5, Section 1, Clause 2 of the Constitution for Virginia. On September 18, 2018, the Supreme Court of Virginia, in its final order, which refused the petition for appeal, which held that there is no reversible error and that the judgment complained of in the final order was given without an opinion or finding of facts and conclusion of law. They cannot. The Constitution requires the Supreme Court and the Appeals Court to give a decision based on facts and conclusion of law. And when they do give a decision based on fact and conclusion of law, They must address each and every contention of a party. California is one such state that has such a clause in its constitution. It said at page 460, 460, 460 pages? I'm sorry, that's 460 pages of its orders for that year. Of the House of Representatives report, then that's the House of Representatives report, on the subject of citizenship of the United States, expatriation and protection abroad. 59th Congress, second section, document 326. Moorish subjects lost their nationality only by becoming naturalized in or protected by another country having treaty relations with the Moorish Empire. Look, this gentleman did his research. Okay, they lost their nationality by becoming naturalized. If you lost your nationality, hold on. Hey, George Benson, you know how I love the greatest love of all. Ladies and gentlemen, this is the greatest love of all. We need to talk. George Benson, I need you to hold on, my brother. And that is my brother, y'all. Literally. I want you all to pay attention to this because you may not be paying attention. And like I said, it's going to be a long video, and a lot of people are not going to be able to handle it because they don't understand the law and they don't understand the information in this video, and that's their problem. Ladies and gentlemen, pay attention to what it said right here. It is said at page 460, paragraph 2 and 3, of the House of Representatives report, the Congressional House of Representatives, on the subject of citizenship of the United States. We're dealing with United States citizens, expatriation and protection abroad. The 59th Congress, second session, document 326. Moorish subjects lost their nationality only by becoming naturalized in or protected by another country having treaty relations with the Moorish Empire. Ladies and gentlemen, if you are naturalized, you can unpatriate yourself from the United States. Doesn't mean that you are stateless. And as a matter of fact, since all of you African Americans were brought to America, none of you are indigenous to America. I know that there were some black people in America, but you don't have to prove that. You don't have to disprove that. See, I have proof that I am a descendant of slaves. That's right. Both my great-great-great-great-grandfathers on my father's side and my mother's side are both from the state of Connecticut. Thanks to that wonderful site that nobody cares about because they will give your information to anybody. Your information is not private on their site. They're called amancestry.com, and amancestry is a piece of website. Okay, ladies and gentlemen, because I am not from America, my ancestors are not from America, I am a naturalized citizen. I was not born in the United States. I am not from the United States. Just like this and other Moorish persons are not members of the United States. So expatriation is what you all should be doing. Do you all understand what I just said? Anyone who is of color, anyone who is of Hispanic descent, anyone who is of Latin descent, Italian descent, anyone who is of, pay attention, European descent. None of you are native to America. So expatriation, like this gentleman did, would seem to be the way. Now, I'm telling you to do your research, ladies and gentlemen. On April 14, 2015, the people of the Moorish American Society reestablished their nation-state government, the United States of America Republic, thereby reclaiming their lost nationality. I told you, if these people came together, you've heard me say it on video time and time again, if they came together as a group and stopped being so dysfractional and disorganized and arguing with each other and everybody wanting to be right, Mr. Bay has showed them the way, but they're not, God, they're so like black people, always arguing with each other, always debating with each other, always cutting each other down, stabbing each other in the back. I apologize. I'm sorry. That wasn't supposed to come out like that. I apologize. No, African American people, those people who don't exist in reality, those people are the most wonderful people in the world. They never argue, they never debate with anybody. But them people of color, them people of color are something completely different. But African Americans, who it's impossible for anybody or anything or anyone to be an African American. You can't be from both places at the same time. They're not even on the same continent. Okay, anyway, let's continue. The United States of America Republic government is a de jure government of an autonomous nation of people whom never conceded their dominions, tenements, herediments, that I've never seen that word before, and I understand the herediments. I understand the word, but I just never seen it like that before. Sovereignty or power. The United States of America Republic is a government corporation created by the Moorish American people. Again, people coming together as a collective creates a corporation. So it's a government corporation created by the Moorish American people to operate in commerce on behalf of the Moorish American people with other government corporations. The USAR state charter was issued by the state of Indiana. The USAR state was also issued its certificate of authority by the State Corporation Commission of the Commonwealth of Virginia, which recognizes the authority and jurisdiction of the USAR state under the fictitious name Providence of Virginia. The Certificate of Authority recognizes the USAR State Charter, which expresses its authority and jurisdiction to exercise all powers. Wait, hold on. The Certificate of Authority recognizes the United States of America Republic State Charter, which expresses its authority and jurisdiction to exercise all powers necessary and are convenient within the geographical borders of what is known as Virginia to effect any and all purposes for its benefit, the life of any of its directors, officers, employees, Moorish American national citizens, and continue such issuance after relationship terminates. It's an official document. They already said it was a valid document, ladies and gentlemen, because it's issued. That charter is issued by the state. Hello? Hello? Anybody paying attention? I hope my Moorish people are paying attention. Mr. Bay, Mr. Wilson Bay, did you all a great service. I apologize. Want you guys to understand, I don't know what the end result was. Reasons for granting the petition. Let's focus on that. Article 6, Section 1, Clause 2 of the Constitution of the State of Virginia. The Supreme Court, Virginia, shall, by virtue of this Constitution, have appellate jurisdiction in cases involving the Constitution of the United States and in cases involving life or liberty, freedom of any person. Due to the court's assertion that it lacked jurisdiction to recognize the authority of the petitioner's nation state government and that it cannot, which authority represents the delegated powers of those fundamental rights of a class of citizens of the United States of America, as well as their collective rights of self-determination, create a conflict with respects to the court's constitutional and international obligations to protect and recognize rights of citizens of the United States of America. Sorry, someone distracted me. Under the 9th Amendment, 10th Amendment, and 14th Amendment, and under certain provisions of the ICCPR, the obligation is crucial to safeguarding the safeguards that this court has in order to secure and ensure that several states uphold its obligations under the United States Constitution and the ICCPR, and that the recognized rights of individuals and classes of people are not unlawfully stripped, and the rights of self-determination and the right to self-government and the right to acquire a nationality, and the right of involuntary servitude, and the right of social, economic, and cultural development, and the right of association. Ladies and gentlemen, the right of involuntary servitude. we don't want to be involuntarily servitude. We don't want servitude at all. Okay? It's the right against involuntary servitude. Now, the Supreme Court don't print nothing unless it's pay attention, unless they've gone over the wording. This court reviewed, it's warranted to ensure the petitioners recognize rights under the 9th and 10th Amendment, and notice it says the 14th Amendment because they repatriatize themselves, and under the ICCPR are not unlawfully stripped. The first issue to settle in order that measures may be taken to safeguard the rights recognized under the 9th, 10th, 13th, 14th Amendment, and I said 10th, but sorry, in this case, is to determine whether or not said rights are secured to the petitioners so that that class of individuals are similarly situated. Now look, they might take a turn to the left, but what I'm saying, and I'll say it again, he did the right thing by expatriating himself. He did the right thing, the Moorish Temple Society did the right thing by setting up the charter and all of that because of what they were trying to accomplish. Again, I am one of Jehovah's Witnesses. I don't take sides. I'm not trying to expatriate myself from the nation to become part of another nation. I'm already part of another nation. It's called the Kingdom of my God. Okay? So that is my nation. So I'm not trying to do any of that. But what I will tell you, it doesn't matter what turn they're about to take, we're going to continue. Okay? Now, a class of individuals similarly situated, the nationals of the citizens of the United States of America Republic. The 14th Amendment provides that all persons born and naturalized in the United States are citizens of the United States and of the state wherein they reside. Now, pay attention. 14th Amendment says they are citizens of the United States and of the state wherein they reside. It is an undisputed fact that the petitioner was born on May 20th, 1964 in the United States, thereby making him a citizen of look at that. They say a citizen of the United States of America. Thus, being a citizen of the United States of America secures to him those rights recognized under the Bill of Rights of the United States Constitution. The First and 14th Amendment provides, 1, the liberty to be in a political association with others for a common advancement of political beliefs and ideas, which is an integral part of the constitutional freedoms. The 9th Amendment provides for the enumeration of certain rights in the Constitution shall not be construed to deny or disparage others retained by the people. The people. The 13th Amendment provides that involuntary servitude shall not exist within the United States or in any place subject to its jurisdiction. The petitioner's petition is that the aforesaid should establish that the petitioner and those similarly situated were citizens of the United States of America when born and presently, thereby securing all rights recognized, rights of citizenship expressly within the United States Constitution. The second issue to settle is to determine whether or not the rights expressed within the provisions of the ICCPR are recognized and secure the petitioner and to that class of individuals similarly situated. The United States ratified the United Nations Charter in 1945. The United States in 1992 ratified the United Nations Treaty, the ICCPR. Before ratifying the ICCPR, the United States submitted certain reservations, understanding, and declarations. According to the United States Senate report, the ratification of the International Covenant of Civil and Political Rights, the ICCPR, USRR, Executive Report, blah, 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 at number 1 declaration communicates that the provisions of Article 1 through Article 7 of the Covenant are not self-executing. Appendix 8, the intent of the making of the non-self-executing treaty is to clarify that the covenant will not create a private cause of action. Furthermore, the committee accepted a proviso offered by Senate Helms that the covenant does not require any legislation or other action prohibited by the Constitution. The petitioner interprets this to mean that the United States courts are to recognize the rights, but if a right that is recognized within the provisions of 1 through 27 is violated, then the United States courts will not recognize the violation as establishing a valid cause of action for the purpose of bringing a suit. According to the USRR committee comments, the ratification of the covenant removed doubt that the United States' commitment to the human rights and enhanced its ability to promote democratic values, and the rule of law. Further, the committee communicates the provisions are compatible with the existing United States domestic laws, and that the ratification has broad support, and the right of association of Article 22 are similar to those contained in the First Amendment, Appendix 20. The number 5 understanding communicates that the covenant shall be implemented by federal, state, and local governments. It further communicates that the competent authorities of the state and local governments shall take measures appropriate for the fulfillment of the covenant. Now, in addition, Item 4 of the ICCPR General Comment Human Rights Committee relating to the nature of the general legal obligations imposed on state parties to covenant states that a state party may not invoke the provisions of its internal laws as a justification for its failure to perform a treaty. The petitioner's position that the aforesaid should establish that the intent of the United States Senate to ratify the ICCPR is for the purpose of recognizing the rights expressed therein, and that the Ninth Amendment of the United States Constitution implies that there are other certain rights retained by the people which are not enumerated. That the Ninth Amendment, I like that point that he brought out. There are other rights that are not enumerated. Common law rights. The Ninth Amendment is the doorway that secures to the petitioner and those of his class those rights under the ICCPR which are not necessarily enumerated within the Constitution but are recognized by the United States via its ratification, and that the intent of making the ICCPR a non-self-executing treaty is to clarify that the covenant is not to create a private cause of action for the purpose of suit, that no legislation or other action prohibited by the Constitution is necessary in order that the rights expressed be recognized, and that such rights are complicated by rights existing in United States domestic law. Mr. Bay is not a junior. Mr. Bay's arguments are unique. They are very literal. He's giving very little wiggle room to get around all of this. Hold on, got to make sure we're still recording, because this has been going on for a while. So let's let you guys understand. He is giving them very little conclusions to make, since he's already done his research. Okay? He's already established the research. You all don't have to do the research. You all incorporate this record into what you're doing. Accomplish the very same points that he's bringing out about your right to self-determination, about your being a member of the class, about your having enumerated rights that are not spelled out in the Constitution, that are not spelled out in statute, that are yours secured by the very sheer fact of you being you. Okay, let's continue. We're on page 23. Got 10 more pages. I don't know if we're going to go through all of it. The third issue to address is how this court's reviewing of this case will prevent the unlawful stripping of the rights mentioned. The Circuit and the Supreme Courts of Virginia, as the competent authorities in the Commonwealth of Virginia and its administration of justice, have a duty and obligation under both the domestic and international laws to protect and uphold the recognized fundamental rights of individual citizens of the United States of America, whom inhabit the territorial boundaries of the area of North America known as Virginia. Again, pay attention. They didn't say United States. They said the territorial area boundaries. It's a geographical location. Supreme Court said that in Miranda. And I'm glad they're still sticking with the same point. The petitioner, being a citizen of the United States of America, has the recognized right of self-determination under Article 1.3 of the CCPR, Appendix number 23. He did an appendix. This right of man is communicated in the Declaration of Independence and extends to the other Moorish American people who are also citizens of the United States of America. This recognized right empowers this class of people to reestablish their nation, state government, As is the case with people of all governments, the Moorish American national and citizen delegated certain rights to their newly reestablished state government, which gives it the authority to act on their behalf for the purpose of which it was created. Thus, the authority of the petitioner's nation state represents the collective and individual rights of the Moorish American national and citizen. This court's intervention is required to ensure that essential components of the United States Constitution and ratified treaty and the rights of self-determination and right of self-government and the right to nationality and freedom of involuntary servitude and the right to social, economic, and cultural development and the right to association is not left unprotected based on the lower court's assertion for lack of jurisdiction. To the recognized thing of the authority of the petitioner's newly reestablished nation state, and so that the unalienable rights of a class of citizens of the United States of America may be exercised in safety and without conflicting with the jurisdiction and laws of the several states during its intercourse. Ladies and gentlemen, I've been asking about the Moorish people because I hadn't heard anything from them. I am glad that I found this article, and I'm glad I'm reading what I'm reading, and I'm going to continue to read this until its conclusion. The prima facie evidence entered by the petitioner consists of certified evidence that established that the petitioner's nation state is recognized by the state of Indiana and the Commonwealth of Virginia, 2 witnesses, as a nation state having its own government, its independence, and its own foreign jurisdiction for the Moorish American national and citizen province of Virginia. The petitioner submitted a notarized, I don't even know why I'm trying to say notarial, but notarized copy of his oath of allegiance to the USAR state. By the natural operation of law, this act of taking an oath to allegiance demonstrates and serves as his repatriation and establishes him as a national citizen of the USAR, residing within the jurisdiction of the province of Virginia. The act of repatriation is an exercising of his right to acquire a nationality under Article 23.4 of the ICCPR. The respondents at any time rebutted or refuted the certified evidence, nor did the circuit court. The respondents at any time, it should be the respondents did not at any time rebut or refute the certified evidence, nor did the circuit court require the respondents to show evidence to the contrary. In fact, the respondents stated if this case were to go forward with the trial, it would be difficult to even comprehend even what kind of thing we have to prove or what kind of fact would have to come out in court. The circuit court provided 2 reasons for applying its decision. First, the court asserted that it lacked jurisdiction to recognize the authority of an independently created state, and that it cannot. Second, due to the mandates within the document referred to by the respondents, the authority exists for the Stanford County entity to tax the petitioner's property. Now pay attention. That court said that due to the mandates within the documents referred to by the respondents, the authority exists by the Stanford County entity to tax the petitioner's property. No, sorry, because their own statutes say they don't have jurisdiction. The petitioner's position is that the court's ruling communicated that it did not recognize the United States of America Republic as a state, being independently created. However, because the court's position is that it lacked jurisdiction to recognize the NSAR's authority, that by default the court has ruled based on those mandates of the Constitution and statutes of the Commonwealth and the state of Virginia that were presented by the respondents. Thus, the lack of jurisdiction reasoned was used to justify the court's decision and to subject the petitioner and his property to taxation statutes, which is involuntary servitude, and ordinances of the Commonwealth and the Stanford County entity. The issue of recognizing the authority of the USAR in this case is so important to the liberty of the petitioner and the national citizens of the USAR that the following is a real and true situation which demonstrates how the liberties of a class of people will continue to be violated without review of this case. See, it's already saying that their liberties are being violated. And if they don't review the case, the liberties will continue to be violated. On January 24, 2018, the petitioner was traveling in his 2015 Honda Civic, and he was stopped by an alleged traffic violation. Pay attention. Y'all, I do need y'all to pay attention because I know what's coming. When asked for his driver's license that was issued to him by the USAR, Bureau of Motor Vehicles, along with a copy of the USAR state charter that expressly authorized the issuance of driver's license to its nationals and citizens, due to the police officer not recognizing the USAR authority to issue licenses, or understanding that it was a foreign license, caused the petitioner to be arrested, jailed, and after being released, compelled to walk several blocks in 40-degree temperature without a coat, due to his Honda Civic being towed and impounded as a result of the arrest, stemming from the officer's lack of awareness of the USAR's authority and its charter right to issue driver's license. Prior to being released from jail, the petitioner was given a date to appear in court on February 22nd, 2018. On the day of court, for undisclosed reason, the Office of the Attorney General for the District of Columbia declined to prosecute the charge of driving without a permit. See, now it's driving without a permit, not driving without a license. Thus, this particular situation evidences how one governmental agency perhaps recognizes the USAR's authority to issue driver's licenses, whereas one agency does not. Similar types of ordeals have been experienced by nationals of the USAR while exercising their liberties as repatriated nationals under the jurisdiction of the authority of the USAR. Uh-oh. Uh-oh. I like it. 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 I mean, I don't wholly condone it, but I like the fact that they're sticking with the law. Now, fortunately, such lack of recognition of the authority of the USAR, the United States of America Republic, has not resulted in a loss of life. However, it has led to the confiscation of property, deprivation of liberty, arbitrary and unlawful arrest and detention, and the violation of rights of the security of persons, all of which are violations under the 4th and 5th Amendment of the United States Constitution, a violation of Title 42 U.S. Code 1983 and Article 9.1. Ladies and gentlemen, Moorish Americans have created their own nation state, and it appears the United States Supreme Court has recognized them. The state of Virginia has recognized them. The state of Washington, D.C. or the so-called District of Washington, D.C. has recognized them. Therefore, if several courts can merely assert that it lacks jurisdiction to recognize the authority of the USAR, pay attention. If the courts can merely assert something, I apologize, and that it cannot and will not facilitate and will facilitate the continual ordeals to be suffered at the discretion of the employees of governmental entities. Okay, the employees of the governmental entities. Sorry, this is a very humid day, and let's just say it's a very humid day. All right. Without this court's review and determinations will result in the stripping of those recognized fundamental human, civil, and political rights and freedoms of the petitioner and those similarly situated. The people of the Moorish American society established themselves as a nation state by exercising, pay attention, their unalienable rights to life, liberty, and the pursuit of happiness, their fundamental right to self-determination, their right to self-government, and their right to a nationality, their right to involuntary servitude, and their right to economic, social, and cultural development. The USAR state government is a representation of the will and desire of its national citizens. The authority of the USAR represents certain delegated powers of each national citizen of the USAR, which powers represent their said rights. Thus, by the circuit courts asserting that it lacked jurisdiction to recognize the authority of the USAR and that it cannot essentially strip the petitioner of his fundamental human, civil, political rights freedoms, and legal protections under the provisions of the USAR Constitution and the laws, and under the United States Constitution and laws, ratified treaties which would preclude the statutes and ordinances of the Commonwealth and State of Virginia and Stafford County entity from being enforced upon the petitioner and upon his property. The actions and lack thereof essentially places the petitioner and those of his class in a condition of involuntary servitude. Oh, look at that. In addition, these actions will also strip the United States of America Republic Government Corporation of its right to engage in commerce and to operate for the purposes of which it was created, to ensure the safety and happiness of American nationals of Moorish descent. Therefore, this court's review will aid to prevent the unlawful stripping of the rights of the newly reestablished nation-state government and provide this court's review will aid to prevent the unlawful stripping of the rights of the newly reestablished nation-state government and provide for the safety of its nationals and citizens by clearly determining what and if any authority should be recognized under the jurisdiction of the courts of the Commonwealth of Virginia and by the courts of the several states. This court should resolve the matter of the Court of Virginia with respects to its lack of jurisdiction to recognize the authority of the petitioner's nation-state government. Ladies and gentlemen, I know I only have a few more pages to read, so you guys will have to excuse me. I have to take a break. I have been going for a minute, but like I said, it's a hot day and I am exhausted. So give me a second. No, not heat stroke or anything like that, just tired. Okay, so I get it. I just had to take about almost an hour break, and it was absolutely necessary because I needed a break.
Give me a break. I sure deserve it. It's time we make it to that time.
Nell Carter, give me a break.
Yes, used to watch Nell Carter. She was my favorite. I love me some Nell.
Okay. Chanel? No, Nell. Look, we're going to go right here. In regards to the court's assertion that it lacked jurisdiction to recognize the authority of the petitioner's nation state and that it cannot understand that, according to Article 1 of the Convention for the Rights and Duties of States, a state as a person of international law possess a permanent population, a defined territory, a government, and a capacity to enter into relations with other states. By another definition, a state is a political community of people permanently occupying a fixed territorial bound together by common law habits and customs into a body politic. Oh, by the way, Section 24, we were going to do a micronation sometime before. Independent sovereignty and control over all persons and things within its boundaries. Keeping the aforesaid understanding in mind, the United States in 1934 ratified the Convention on Rights and Duties of States, called CORDS, Treaty Series 881. This convention covenant communicates that the recognition of a state may be express or tacit, or that tacit recognition is any act that implies the intention of recognizing a new state. The recognition of a state signifies that the state which recognizes it accepts the personality of the other with all of the rights and duties determined by international law, and that recognition is unconditional and irrevocable. That jurisdiction of the state applies to all inhabitants within the limits of national territory, and the state has the right to provide for its conservation and prosperity, and consequently to administer its services. As evidence, the petitioner submitted exhibits with his petition for appeal. Exhibit C was Certificate of Authority, COA, that his nation state was issued by the Commonwealth of Virginia State Corporations Commission. To secure the COA, the petitioner nation state submitted a full charter to the SCC, along with its certificate of assumed and fictitious name, both of which classifies it as a nation-state government and as being a foreign corporation doing business as the province of Virginia within the territorial borders, what is known as Virginia. In accordance with the laws of the Commonwealth, the COA Certificate of Authority was issued by the SCC of the Commonwealth of Virginia, signed by Joel H. Peck, Clerk of the Commission. According to the Secretary of the Commonwealth, Kelly Thomason, the authenticated copy of the COA expressed by Joel A. Peck is authorized by the laws of the Commonwealth to make and sign such instruments, and to all official acts, full faith and credit and authority are due and ought to be given. The issuance of the COA indicates that the Commonwealth of Virginia recognizes the foreign status, jurisdiction, power, and authority expressed within the petitioner's nation-state charter, and its sovereignty and independence, which the charter also expresses. They are a sovereign nation, ladies and gentlemen. The issuance of the COA is an official act, thus indicating that the laws of the Commonwealth grants and empowers the state of Virginia and Stafford County entity, its courts and all parts thereof, jurisdiction to recognize the granted authority of the petitioner's nation-state. Thus, the Commonwealth's SCC issued the COA Certificate of Authority without objection. This indicates that the Commonwealth and all parts thereof shall recognize the authority and power of the petitioner's state in accordance with the provisions of the Virginia Non-Stock Corporation Act. Therefore, it is through the official act of the General Assembly of the Commonwealth of Virginia, passage of the Virginia Non-Stock Corporations Act, that the official act of the SCC issuance of the COA gives jurisdiction of the courts of Virginia to recognize the authority, jurisdiction, and power of the petitioner's nation-state. The COA further serves as a contract between the two states. The action taken by the courts of Virginia impair the contractual obligations that the COA, Certificate of Authority, creates between the two states. Such actions taken in violation of the laws against impairment of obligation of contracts, Clause Article 1, Section 10 of the U.S. Constitution. Furthermore, the courts of Virginia act of not recognizing the issued COA would also be a violation of the Full Faith and Credit Clause, Article 4, Section 1 of the United States Constitution. That provides that the full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. The aforesaid serves to demonstrate that the Circuit and Supreme Courts of Virginia, under its domestic laws, is empowered and granted jurisdiction to recognize the authority of the petitioner's nation-state via the issuance of the nation-state charter and COA, executed under the official acts of the Commonwealth, SCC, General Assembly, and the State of Indiana's Secretary of State. In addition, pursuant to Article 7 of the courts, the mere issuance of the nation-state charter and COA is at the very minimum a tacit act of recognition of the government of the nation-state's authority by the State of Indiana and the Commonwealth, which implies their intention of recognizing the new state of the Moorish American national and citizens. This act of recognition signifies that the Commonwealth of Virginia accepts the personality of the nation state with all its rights and duties, even under international law. According to number 5 understanding submitted by the United States, the courts of the Commonwealth are empowered and granted jurisdiction to recognize the authority of the petitioner's nation state, so to assist the United States to fulfill its obligations under the provisions of the ICCPR for the purpose of securing the petitioner's recognized rights therein. The petitioner's petition is that based upon the aforesaid, there is no rational basis for the Circuit or the Supreme Court of Virginia to assert that it lacks jurisdiction and cannot recognize the authority of the petitioner's nation state. This case outlines the questions presented. The case presented is excellent vehicle to address the questions raised and for the purpose of determining whether the current and future nationals of the citizens of the USAR shall remain in a state of involuntary servitude to the several states of the United States, or whether their rights to provide for their safety and happiness shall be recognized. In addition, this case will make clear whether the lower court shall recognize the chartered right, constitution, laws, and jurisdiction of the USAR. Make clear whether property owned by the current and future nationals and citizens of the USAR will be subject to property taxation statutes and ordinances of the several states of the United States. Make clear the legal reasons and conditions under which the property owned by the USAR nationals and citizens may or may not be subject to taxation statutes and ordinances in the several states. And number 4, make clear whether the lower court shall recognize the nationality of the current and future nationals of the citizens of the USAR. The interest at stake here is of utmost importance. This case not only presents the legal question involved, but whether the authority of an independently created state established according to law, representing the fundamental human, civil, and political rights and freedoms of a class of citizens of the United States of America shall be recognized by its highest court. The petitioner entered prima facie evidence that consisted of certified evidence that established that the petitioner's nation state is recognized by the state of Indiana and the Commonwealth state of Virginia as a nation state, having its own state government, its own foreign power, a province of Virginia jurisdiction for the Moorish American national and citizens, and its independence. The recognition given by the state of Indiana and by the Commonwealth and state of Virginia is an act of state evidenced by the issuance of the USAR Charter, the Certificate of Authority. This court should intervene to make the aforesaid determinations and clarifications for the purposes of mitigating and any possible conflict between the several states' jurisdictions during the intercourse, and for the safety and happiness of the American national Moorish descent. Conclusion. Never in modern times have the American people of Moorish descent, misnomered as African American, black, Negro, colored, taken upon themselves to assume among the powers of the earth to the separate and equal station to which the law of nature and nature's God entitles them. It is held that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them are the right to liberty, to life, to pursuit of happiness, that to secure these rights, governments are instituted among men. That's right, they get to create their own government. Deriving their just powers from the consent of the governed, its foundation on principles, and organizing its powers on such a form as to them shall seem most likely to affect their safety and happiness. By finally comprehending this well-established holding clause, the Society of the American people of Moorish descent to establish themselves a government laying its foundations on principles, organizing its powers in such forms as to them shall be seen most likely to affect their safety and happiness. For these reasons, the petition of certiorari should be granted. Respectfully, I'm sorry, I apologize. I did this whole video. I'm thinking that this is what the Supreme Court decided, but this is not what they decided. This is what this gentleman filed. So now I got to stop this whole video. Oh Lord, can't do the video because when I looked at it, it didn't look like it was a petition filed. It looked like it was a decision that the Supreme Court was coming to. I actually like the way it was done, but I can't post this video. It's a petition for writ of certiorari. But I do like the way it was done. Okay, so that's it. I can't even finish this video. That's what I get for not reading the whole thing. Gotta go. Alright, end the video.